Imelda Romualdez-Marcos vs. Commission on Elections and CIRILO Roy Montejo. GR number 119976. September 18, 1995. Facts. Petitioner Imelda Romualdez-Marcos filed her Certificate of Candidacy for the position of Representative of the First District of Leyte in 1995, providing that her residence in the place was 7 months. On March 23, 1995, CIRILO Roy Montejo, the incumbent representative of the First District of Leyte and also a candidate for the same position, filed a petition for cancellation and disqualification with the COMELEC, charging Marcos as she did not comply with the constitutional requirement for residency, as she lacked the Constitution's 1-year residency requirement for candidates for the House of Representatives. In her amended corrected Certificate of Candidacy, the petitioner changed 7 months to since childhood under residency. Thus, the petitioner's motion for reconsideration was denied. On May 11, 1995, the COMELEC issued a resolution allowing petitioner's proclamation showing that she obtained the highest number of votes in the congressional elections in the First District of Leyte. The COMELEC reversed itself and issued a second resolution directing that the proclamation of petitioner be suspended in the event that she obtains the highest number of votes. In a supplemental petition dated May 25, 1995, Marcos claimed that she was the overwhelming winner of the elections based on the canvass completed by the Provincial Board of Canvassers. Issue: whether or not Imelda Marcos was a resident of the First District of Leyte to satisfy the 1-year residency requirement to be eligible in running as representative. Ruling: yes. The court is in favor of a conclusion supporting petitioner's claim of legal residence or domicile in the First District of Leyte. Residence is synonymous with domicile, which reveals a tendency or mistake the concept of domicile for actual residence. A conception not intended for the purpose of determining a candidate's qualifications for the election to the House of Representatives as required by the 1987 Constitution. An individual does not lose her domicile even if she has lived and maintained residences in different places. In the case at bench, the evidence adduced by MONTEJO lacks the degree of persuasiveness as required to convince the court that an abandonment of domicile of origin in favor of a domicile of choice indeed occurred. It cannot be correctly argued that Marcos lost her domicile of origin by operation of law as a result of her marriage to the late President Ferdinand E. Marcos. It can be concluded that the facts supporting its proposition that petitioner was ineligible to run for the position of representative of the First District of Leyte. The COMELEC was obviously referring to petitioner's various places of actual residence, not her domicile. Having determined that Marcos possessed the necessary residence qualifications to run for a seat in the House of Representatives in the First District of Leyte, the COMELEC's questioned resolutions dated April 24, May 7, May 11, and May 25 are set aside. Provincial Board of Canvassers is directed to proclaim Marcos as the duly elected representative of the First District of Leyte.